You're welcome to this presentation on criminal law. The topic of our presentation is Defenses to Criminal Liability, Part 1. In the course of the semester, we have begun to look at the legal elements of an offense. We looked at the physical elements of an offense. We looked at the mental elements of an offense. And we said that it's a combination of the two that will be sufficient to ground liability for an offense. But despite the presence of the physical element of an offense and the mental elements of an offense, there is still the very important issue of criminal responsibility. The germane question is, the defendant who has committed the act with the requisite mental element, is he criminally responsible for the offense? In other words, is the defender at fault for the offense to such an extent as to be blameworthy? The question of criminal responsibility goes to blameworthiness. Does this defendant deserve to be punished under the rules of criminal law? The criminal law has outlined certain rules and principles which govern the question of criminal responsibility. In other words, even where the offender has done the prohibited act or made the prohibited omission with the requisite mental element, the question is still relevant as to whether the defendant is criminally responsible, as to whether the defendant is blameworthy. Now, we'll be looking at the general defenses to criminal responsibility. These are defenses that applies to all offenses, subject to some limitation and restrictions that makes some of the defenses to be applicable to specific offenses. So we'll be looking at those defenses to criminal responsibility. But today we will start by looking at some of the governing principles that runs through several of these defenses. And those governing principles can be found on the concept of justification or excuse. And we'll start with that today, and we'll look at a couple of the preliminary, a couple of the general defenses to criminal liability. So just give me about 2 or 3 seconds as I share my slides so that you can also follow as we go along. Okay, I believe you can all see my slides now. Defenses to criminal liability. My name is Hakeem Olajide Bello. I'm of the Department of Public Law, Faculty of Law, University of Lagos. So, briefly, the lecture will cover general principles such as justification, excuse, and other grounds of impunity. And then we'll then begin to look at some specific defenses, and we'll see whether there are defenses founded on justification or founded on excuse. What are the learning objectives for this class? There are basically 2 learning objectives. The first one is that at the end of the lesson, the students should be able to understand the general principles governing defenses to criminal liability, founded on justification, excuse, and other grounds of impunity. The second learning objective is that at the end of the lesson, we expect that the students should understand the rules governing the application of specific defenses, such as self-defense, minority, insanity, and so on and so forth. And for the learning outcomes, we expect that at the end of the lesson, students should be able to do the following. Number 1, explain the general principles governing defenses to criminal liability, founded on justification, excuse, and other grounds of impunity, and explain and apply the rules governing the application of specific defenses. We're going to be looking at some specific defenses consequently, and so we expect that the student, after the class, should be able to explain and apply the rules governing the application of specific defenses. These rules are, of course, founded on statutory provisions and judicial decisions. Now we want to look closely at the general principles which runs through several of the defenses. And we'll start by looking at justification. So what are the general principles? A defendant whose conduct is within any of the grounds of justification, excuse, or other grounds of impunity provided by the law may escape criminal liability. In defenses based on justification, the law takes the position that the defendant's conduct is not wrong because the law permits it. The defendant has done a conduct that is wrongful within the definition of offenses under the criminal law. But the law takes the position that the defendant's conduct is not wrong. The defendant's conduct is not wrong because the law permits it. Now, in justificatory defenses, the harm caused by the justified behavior remains a legally recognized harm, which is to be avoided whenever possible. In justificatory defenses, the defendant is allowed to cause some harm. Now, the harm caused by the defendant is a legally recognized harm. For instance, a defendant who is relying on the plea of self-defense and takes an action which results in the death of the assailant. The death of the assailant remains a legally recognized harm. But under the circumstances of the defendant trying to protect his own life from unjustifiable and illegal attack or assault, the law allows that defensive conduct. Now, under the justifying circumstances, however, that harm is outweighed by the need to avoid an even greater harm or to avoid a greater or to further a greater societal interest. Now, like we said earlier, harm is caused by the victim who is exercising a plea of self-defense. Harm is caused, no doubt. It is a legally recognized harm. The assailant has been killed in the case of a plea of self-defense. But the harm of killing the assailant is outweighed by an even greater harm. And that greater harm is the harm of the assailant who has unlawfully and unjustifiably threatened to attack or is attacking or has attacked the victim. So there are two harms here. The harm done by defensive conduct is one harm. The other is the harm that the assailant is trying to inflict on an innocent victim. So the harm under the justifying circumstances outweighs the greater harm of the law allowing an assailant to threaten or take the life of the victim without any legal basis. Now, a writer, Paul Robinson, identified three types of justification-based defenses, three types of justification-based defenses. The first is what he called lesser evils or choice of evil justification. Lesser evil or choice of evil justification. Now, in this type of justification-based defenses, the claimant had a choice. The claimant had a choice between two evils and chooses the lesser evil. Now, let me give an example to illustrate this point. You are driving your vehicle along the road at a reasonable speed, having regard to the level of traffic and pedestrians on the road. So your driving was reasonable within the circumstances. And a toddler suddenly walking by the side of the road, suddenly tries to run across the road. Now you had a choice between two evils, a lesser evil and a greater evil. There are parked on the side of the road are cartons of soft drinks. So you had you have two evils. One is to run over the child who suddenly runs across you because of the distance of the child trying to run across you and where you are at the point of driving, you could not match your brake sufficiently enough to avoid hitting the child. So you had two choices. One was to run into the child or to swerve off the road and damage the carton of soft drinks by the side of the road. Now, that was a situation of emergency. That was a situation of necessity. And you had to act on the spur of the moment. So the lesser evil is the evil of swerving off the road and damaging the carton of soft drinks. Of course, that ordinarily would have amounted to the offense of damage to property. But in the circumstances of the case, you took a justified course of action. Although your action of swerving off the road and damaging the carton of soft drinks is something that constitutes an offense. But because of the circumstances, the law allows you to pick between two evils and to take a lesser evil. Now, in that kind of a situation, a charge of damaging or destroying those carton of soft drinks cannot be successfully laid against you because you had a justification-based defense. Now, the second type of justification-based defenses is the defensive force justification, where the law allows harm to be done for the purpose of defending self or property. Now, in the second scenario, the law allows you to use what is called defensive force for the purpose of defending yourself or for the purpose of defending property. Now, this also involves weighing harm to be done by the defensive force against harm to be done by not allowing the defensive force. Where threatened harm outweighs defensive harm is allowed. Somebody brings out a gun and shoots at you. And because you had undergone military training, you are able to evade the bullet the first time, the second time. And the guy, the assailant, kept on trying to kill you. And then you also had a gun nearby, and you, because of your military training, you were able to quickly bring out your gun, shoot at the assailant, and kills him. Now, here, the law allows you to use defensive force against the harm that is threatening to you. And if the harm that is threatened against you outweighs defensive harm, because if you do not kill the guy or do something drastic to him, the guy is likely to end up killing you. So in this circumstance, defensive harm is allowed. Now, the law allows different degrees of defensive force depending on what is threatened. If it is a life that is threatened, there's a degree of defensive force that is allowed. If it is a movable property that is threatened, there's a degree of defensive force that is allowed. If it is immovable property that is threatened, there is a degree of defensive harm that is allowed. For instance, somebody who is threatening to assault you, ordinary assault, common assault, maybe tries to throw water on you, cold water on you, okay? That is an ordinary assault. That kind of assault, you are not allowed to respond with the kind of assault or violence that is likely to threaten his life. Okay, if he throws cold water at you and you give him a dirty slap, that may be within the permissible degree. Now, if it is movable property, generally the level of defensive force that the law allows for you to use when you are defending your movable property is not as high as the level of, as high as the degree of defensive force that the law allows you to use when you are defending your immovable property. Movable property, maybe like a phone or like a vehicle or like, other valuable movable property. Ordinarily, the law does not allow you to use such force as is likely to take human life when you are defending movable property. But when you get to the level of immovable property, somebody is trying to set your house ablaze. Now, the law allows you to use a higher degree of defensive force. And in certain circumstances, the law may even allow you to use such degree of defensive force that may result in the death of the assailant. So different degrees of defensive force is allowed depending on what is threatened, whether it is life, whether it is movable property, or whether it is immovable property. Now, the third category of justification defenses is what is called public authority defense. Now, in this category, there is no requirement that the defense be triggered by a threat. All that is sufficient is that the actor is protecting or furthering a legally recognized interest. Now, in public authority defense, there may be no requirement that there is a threat sought to be, applied against the claimant. What is important is that the person claiming public authority defense is protecting or furthering a legally recognized interest, is acting in pursuance of a legally recognized interest. Now, the people who may come under this umbrella include law enforcement officers executing the law. Now, a law enforcement officer who is executing the law can rely on public authority defense. Ordinarily, what law enforcement authorities do when they are enforcing the law may constitute a crime. A police officer acting under the rules of criminal procedure law or administration of criminal justice law who wants to arrest an offender who has committed an offense in his presence is allowed to use such degree of force as may be necessary to apprehend the offender. If the offender is trying to escape, he is entitled to grab him or run after him or apprehend him using force to restrain him. Now, that use of force, ordinarily, if the officer was not acting in pursuance of the law under public authority, could constitute an assault. So, law enforcement officers can come under the umbrella of public authority defense. Then parents, under the law, parents have some level of authority to discipline their wards. So you have the authority to discipline your child who has done something wrong. Now, that is a legally recognized interest because society recognizes the fact that children can, often misbehave and we need to correct them. But again, the level of correction that the parents can impose has to be reasonable. You can physically chastise a child or use a cane, or other devices minimally, to discipline a child. But you are not allowed to use such force as is likely to cause grievous harm to the child. Similarly, masters or educational institutions caring for a child are allowed to use reasonable force to correct such child. Those are examples of justification-based defenses under the general rubrics of public authority defense. Now, one unique feature to all justification defenses is that they have the same internal structure. They have the same internal structure involving a triggering condition which permits a necessary and proportional response. So usually in justificatory defenses, there is a trigger. And that trigger, allows for a necessary and proportional response. In cases of self-defense, the trigger is the threatened harm or harm inflicted on the claimant. In public authority defense, the trigger is that the person is acting under a legally recognized interest, is furthering a legally recognized interest. For instance, is acting under the under duty, required by law. In defensive force justification, the assailant must have attempted to apply unlawful force to the interest protected by law. He must have attempted to apply unlawful force to the interest protected by law before the claimant will be at liberty to use necessary and proportional defensive force. If disproportionate and unnecessary force is used, then the defense will fail. The defense will fail. In justification-based defenses, the force used must be proportional. If it is disproportionate or is unnecessary, having regard to the circumstances, then the defense will fail. A police officer who is furthering a legally protected interest of arresting an offender or a suspect, who uses more force as is reasonably necessary, or who uses disproportionate force to effect the arrest, will be liable for assault because that defense will fail. If the suspect is not resisting arrest, the policeman tells him you are under arrest and he surrenders himself to be arrested, and yet the policeman still beats him up, knocks him, pushes him down, kicks him, then the police officer will no longer be entitled to the defense because the force that he's using is unnecessary and disproportionate. Now, based on the above analysis of the essential features of justification-based defenses, the following defenses may be classified as justificatory in nature. Of course, we've already mentioned self-defense. I've already given the example of necessity when you are driving on the road and a toddler suddenly runs across the road. I've given the example of public authority. I've also given the example of disciplining of children and some other example. Now, we want to look at excusatory defenses. We want to look at defenses based on excuse and to look at their essential features. Now, in excusatory defenses, the deed is wrong. The offender or the claimant has done something the law says should not be done. But the defendant is relieved from criminal liability because conditions suggest that he is not responsible for his deed. So, in excusatory defenses, one important feature of excusatory defenses is that the claimant is laboring under certain conditions, and those conditions affected him in such a manner as not to make him to be responsible for his deed, as not to make him to be accountable for his deed, as not to make him to be blameworthy for his deed, as not to make him to be at fault for his deed. And because of those conditions which has created his inability, to be responsible, to be accountable, to be blameworthy, to be at fault, the law frees him from criminal liability. The law excuses him from criminal liability. In excusatory defenses, just a minute. I think the slide just jumped. Okay. In excusatory defenses have one internal structure. And that internal structure is that there is a disability causing an existing condition. The offender or the claimant is laboring under a disability. And that disability causes a condition which makes the defendant not a fully free and responsible agent as to be fairly held accountable. The claimant has a disability, and that disability causes a condition that makes him not to be a free agent. In other words, he's not fully in control of himself. He's not fully in control of his action. And because he's not fully in control of the action, the law takes the position that we should not hold him responsible. We should not punish him because he was not fully responsible. Now, what are the examples of some of the disabilities which causes abnormal condition? Examples come from insanity. A defendant who is mentally unstable, who is not mentally able, who is suffering from some mental condition that impairs his ability to control his action or to know what he is doing, the law will not hold such a defendant liable for any offense he has committed in that state. That is essentially the basis of the plea of insanity. There is also intoxication. Although the law ordinarily concerns itself here with involuntary intoxication, where a defendant is involuntarily intoxicated. Maybe it's unknown to him, somebody spiked his drink or put something in his water that intoxicates him, or puts a drug in his drink that intoxicates him, thereby making him not to be in a condition as to be able to control his action. Whatever offense or offenses he commits in that state, the law will excuse him, will free him from criminal liability. Then we also have some situation in which the offender is subnormal, is laboring under a condition that does not make him to behave the way an ordinary person would behave, or is a situation where the defendant is immature in terms of age. For instance, there are certain categories of age under the criminal law. If you are below the age of 7, the law says you cannot be responsible for an offense. And in states in Nigeria that still operates the criminal code, in southern Nigeria, the criminal code says a person under the age of 12 is incapable of having unlawful carnal knowledge. So a male child under the age of 12 cannot commit the offense of rape. So those are situations in which the offender is immature, is not fully mature, is a minor under the law. And because he's a minor, his level of development is a form of disability, which makes him not fully responsible. We all know that children are not fully responsible in terms of development of their intellect, in terms of their development of their mental capacity to be able to rationalize and reason and do certain things. So the law affords them the defense of immaturity based on the grounds of excuse. Now, most excusatory defenses completely exculpate. What that means is that most excusatory defenses will completely, free the defendant from criminal responsibility. For instance, the defense provocation as a defense for assault under Section 84 of the Criminal Code. That is a defense that completely exculpates. If somebody provokes you as a result of which you assault him, then the law will allow you to raise a plea of provocation. And if your plea succeeds, then you are free from liability. Section 84 of the Criminal Code. Of course, we also have the defense of insanity, where a defendant is able to successfully make a plea of insanity, then the court will enter, even if it is found that he did the act or made the omission. But for as long as he did it while he was still insane, then the court will enter a verdict of not guilty by reason of insanity. Although there are some other procedural consequences that will follow after that. When we look at the defense of insanity, we examine that fully. And like I've said earlier, there's also the defense of immaturity. Whatever the offender does when he's under the age of 7, then is not responsible. But between the age of 7 and 12, under the criminal code, then the law allows evidence to be brought in that the defendant was sufficiently mature enough to know that what he was doing was wrong. And if that can be established, then the defendant can be liable in that regard. But once, if it is a plea of immaturity made by a person under the age of 7, or in states in southern Nigeria that still applies the criminal code, a person who is under the age of 12 is incapable of having carnal knowledge. So it provides for a complete excuse. Now, the following are offenses where the excuse will only be partial. The criminal law also allows for certain situations where a successful plea of excuse will only lead to a reduction in the punishment, a reduction in the gravity of the offense, and consequently a reduction in the punishment that the offender would receive. For instance, if a defendant who is charged with the offense of murder successfully raises a plea of provocation, in other words, he claims that, well, it was the victim that, provoked him by grave and sudden provocation, and he did not have time for his passion to cool, and in the course of that, he murders the victim. The law, if the plea succeeds, then the law would the court will find him guilty of the lesser offense of manslaughter. And the consequence of that is that he will be sentenced to a term of years, depending on the circumstances of the case. We also have the excusatory defense of diminished responsibility. Because of the technical nature of the offense of insanity, as we'll see when we get there, a defendant who is not able to successfully raise the defense of insanity may be able to raise the defense of diminished responsibility, which is a defense that is now incorporated in Section 228 of the Criminal Law of Lagos. That defense contemplates that although the defendant may not be legally insane, but the defendant was suffering from such other emotional or psychological state that leads to the impairment of his responsibility to such an extent that he should not be found liable for the offense of murder. So the law allows for the defense of diminished responsibility. So we have looked at the general principles and the general features of justification-based defenses and excusatory defenses based on excuse. So we now want to look at some of the justification-based defenses. Remember, we said that one is that where the defendant is acting under a public duty or orders of the authority. Nigerian criminal law justifies what will otherwise be a crime when the act or the omission constituting the crime is carried out in discharge of a public duty, in execution of the law, or under superior orders. So where the claimant is discharging a public duty, is executing the law, or is executing the orders of the superior court, then it cannot be held liable for any offense. People who execute the order of a court may, take certain steps that ordinarily would constitute an offense, but the law provides them with protection from that. Now, judicial officers. We know the role of judicial officers in our criminal justice system. They interpret the law, they apply the law, and they determine the law. And because of the nature of their responsibilities, sometimes they make orders or give orders which may result in certain actions which ordinarily may open them up to criminal liability. So because of the need to protect them in the discharge of their functions and to create an atmosphere that will make them free from any unnecessary threat of criminal action against them arising from the discharge of their duty, the law provides immunity for judicial officers from criminal liability. The law provides immunity for judicial officers from criminal liability. So the law affords them criminal immunity from criminal liability under Section 46 of the Penal Code and under Section 31 of the Criminal Code. And this protection extends to acts or omission done in the exercise of judicial functions. So whatever they do in the exercise of their judicial functions, you know, in the course of their judicial functions, they make orders. They can find a person guilty of an offense. They can make an order that property should be demolished. They can make an order that somebody's property should be forcefully taken in execution of the orders of a court. They may make an order that a defendant who has been found guilty should be sentenced to imprisonment, or they may make an order directing the offender to go and render community service. So all these are acts done in the exercise of their judicial functions, or maybe in the course of exercising their judicial functions, the offender or either of the parties before them may constitute himself into a nuisance in the court, in the course of the proceedings of the court. By trying to disrupt the proceedings of the court may, cite him for contempt and order him to be imprisoned. So these are all, exercises done in the course of their judicial function. The Criminal Code provisions in Section 31 covers judicial acts or omissions in exercise of judicial functions. Judicial acts or omission in exercise of judicial functions and in excess of his authority. So the law covers whatever they do in excess of authority. Now, why should the law cover them when they do anything in excess of judicial authority? Courts interpret the law, they apply the law, and they apply the law to make decisions which they believe is within their judicial authority. And they need to be given the freedom and the protection to do what they believe is within their judicial powers. But in doing that, they may also do something that is in excess of their judicial authority, innocently, mistakenly. And that is why we have the appellate court system. You may find a situation in which the High Court will say, the answer to this legal question is A. The litigants not happy with that decision may go to the Court of Appeal. And the Court of Appeal will say, no, the trial court is wrong. The answer is B. And the party who loses at the Court of Appeal may also say, no, I don't agree. I'm going to the Supreme Court. And the Supreme Court will say that both A and B are wrong, and the answer is actually C. Now, if you now allow litigants to be able to pursue actions against the trial court, who had initially said the answer to the legal question is A, judicial officers will not be able to discharge their functions, freely and fairly, because they will be anxious not to do what is wrong. Ordinarily, they should be anxious not to do what is wrong. But when it comes to judicial authority, sometimes they make innocent mistakes. And that is why the law covers anything they do in excess of their judicial authority. Although that is not a liberty for them to deliberately go outside the ambits of their judicial authority. Now, a judicial officer who acted in excess of authority will also be covered under the provisions of the Penal Code, although the Penal Code provision does not explicitly cover excess of judicial authority. But I believe that a judicial officer who acted in excess of authority will also be covered under the Penal Code if he believes in good faith that the law gives him such powers. Now, does judicial immunity in Nigeria cover acts done by judicial officers maliciously? Now, when they do something maliciously, what that implies is that they've done that thing for an improper purpose, or maybe for a purpose that is not connected with the exercise of their judicial functions. So the question is, does judicial immunity in Nigeria cover acts done by judicial officials maliciously? The use of the word good faith by the Penal Code arguably exclude malicious acts from the scope of the immunity. I mean, if you look at the provisions of Section 41 of the Penal Code that Section 46 of the Penal Code that I referred to earlier, it uses the word that, provided that whatever they do, they believe in good faith, that the law allows them to do it. So the use of the words good faith by the Penal Code arguably exclude malicious acts from the scope of the immunity. Now, in the English case of Anderson and Gorey, 1895 1 QB, page 668, it was held that no action, civil or criminal, lies against a judge of a superior court in respect of any act done by him in his judicial capacity, although he acted maliciously. That is the position in England. Their own position is that, well, for as long as the action is done by a judge of a superior court in respect of anything done in his judicial capacity, even if he acted maliciously, no civil or criminal action can lie against him. But I agree with the view expressed by Professor Chuko, that the decision will not apply under the provisions of the Criminal Code. The decision will not apply because the Criminal Code has already circumscribed the scope of what they can do in exercise of their judicial authority. So whatever they do must be done in the exercise of their judicial authority. If they acted maliciously for an improper purpose, that cannot be said to be done in the exercise of their judicial authority. So I agree with him that a Nigerian court should not follow the decision in Anderson and Gorey. Now, acts in execution of the law. Acts in execution of the law. A person is not criminally responsible for an act or omission if he does or omits to do an act in execution of the law. If he does an act in execution of the law. So if what the offender has done is in pursuance of executing the processes of law. I gave the example of the police officer arresting an offender. And even under the rules of criminal procedure or addition of criminal justice, even a private citizen is empowered in certain circumstances to arrest an offender. So whatever is done within reasonable limits in pursuance of that duty to arrest an offender is an act done in the execution of the law, and the person will not be criminally responsible for that. A person is not criminally responsible for an act of omission if he does or omits to do an act in obedience of the order of a competent authority for which is bound by law to obey, unless the order is manifestly unlawful. So if you are a police officer, you are on duty in a courtroom, and one of the litigants or the defendant becomes unruly and wants to begin to disturb the proceedings of the court, and the court orders the police officer on duty to arrest him and take him out of the courtroom, the conduct of the police officer in arresting that unruly person and taking him out of the courtroom is in obedience of the order of a competent authority and is bound by law to obey it, unless the order is manifestly unlawful. Of course, in this instance, the order is not manifestly unlawful. In the same vein, a superior officer, a superior police officer, who gives a directive to a junior officer to arrest an offender, and the junior officer arrests the offender, the junior officer will not be liable for anything done within reasonable limits in carrying out that order. Of course, it's also important that the order must not be manifestly unlawful. Section 47 of the Penal Code specifically includes the requirement that the protection applies, notwithstanding that the court may have had no jurisdiction to pass such judgment or order. Now, how will the person enforcing the order know that the court had no jurisdiction to pass such judgment or order? There was no way he will know, so he will be protected. So the protection, applies, notwithstanding that the court may have had no jurisdiction to pass such judgment or order, provided the person doing the act in good faith believes that the court had jurisdiction. As far as he's concerned, he's in the courtroom, the court asks him to arrest somebody who is behaving unruly or disturbing proceedings of the court and take him out of the courtroom. That is a proper order. And in good faith, he believes he cannot now be liable for any criminal action with respect to that. The same position will also apply under the criminal code, even in the express provision. Yes, even under the criminal code, if you are enforcing the order of a court of competent jurisdiction, how is the person enforcing the order, like I said earlier, how is it to know that the court made the order properly, or the court made the court that made the order had jurisdiction to make the order? A person is not criminally responsible for an act of omission if he does or omits to do the act if he does or omits to do the act, if his action is justified by law. So if you can otherwise show that what you have done is justified by law, the law allows you to do it, the law permits you to do it, then you cannot be responsible. Section 45 of the Penal Code. Now, superior orders. Let's look at it as superior order. A person who has no criminal responsibility under Section 32(2) of the Criminal Code for an act or omission in disobedience, for an act or omission in obedience of the order of a competent authority, which the person is bound by law to obey, unless the order is manifestly unlawful. I've said something about that earlier. Now, let's look at the aspect of the requirement that the order must not be manifestly unlawful. Yes, if you are under authority, you are bound to obey orders of a competent authority. If you are in the military, or you are in any of the armed forces, or you are in any position that you have a competent authority presiding over you, the law requires you to obey their orders. The law requires you to obey their orders, provided that the order is not manifestly unlawful. What that means is that the order is not Another that you know that I'm not bound by law to obey this order. For instance, if you are working in the armed forces and your superior orders you to arrest another person who has violated the provisions of a law, that is a manifestly lawful order. If you carry out the arrest, you cannot be responsible for any offense. But if your superior, you are going on the road and you are the security officer attached to your superior commander, and in the course of driving on the road, an Okada man hits the official car of your commanding officer, and your commanding officer was so annoyed, he alighted from the vehicle and orders you to shoot the Okada rider. That is a manifestly unlawful order, because there is nothing that the Okada man has done that justifies you killing or shooting the Okada man. So if you obey such an order, you do not have any legal protection under the law. The law will not protect anybody who obeys a manifestly unlawful order. Both the person who gave the order and the one to whom the order was addressed, who carried out the order, both of them will be liable depending on the circumstances. If in the example that I've given, you manifestly, you obeyed the order of your commander and you gunned down the Okada man, the only offense he has committed is that he used his Okada, to damage the official vehicle of your commanding officer. That is not sufficient enough to justify the order made by your superior to shoot and kill the Okada man. So both the commanding officer and the person who carried out such an order will be liable for whatever offense has been committed. You can see the case of Ibikunle and the state. Now, that is the presentation for Defenses to Criminal Liability Part 1. So I want to thank you for your attention. Now, there'll be opportunities for you to ask questions. If there is any aspect of the class that is not clear to you, you can ask your questions or request for clarification. Thank you for listening to it. I hope you'll find time to listen to it so that you can come to class prepared for questions, and I will be available in the course of the lecture to explain any area that needs clarification, any area that needs any additional input. Do not forget to subscribe, to click the subscribe button so that when I post subsequent lectures, you'll be able to access them. Thank you very much. God bless.